Tell me about the process that led to your nomination. Did anyone ask you to make any promises or assurances at all about your view on certain legal issues or the way that you'd rule in certain cases?
Senator, I think you'd be reassured. But I did hear lots of talk of litmus tests from all around. It was in the air. And I don't believe in litmus tests for judges. I've written about that years ago. I wasn't about to become party to such a thing. I don't believe in litmus tests for judges. I've written about that. From the time I was contacted, was an expression of interest for a potential interview, to the time I was nominated. No one in that process, Mr. Chairman, asked me for any commitments, any kind of promises about how I'd rule in any kind of case. I wasn't about to become party to such a thing. And I don't think it's appropriate for a judge to do so, no matter who's doing the asking. And I don't because everybody wants a fair judge to come to their case with an open mind and to decide on the facts and the law. One of the facts and one of the features of law that you have to decide it on is on the basis of precedent, as you point out. And for a judge, precedent is a very important thing because no one in the process. Precedent is kind of like our shared family history as judges. It deserves our respect because it represents our collective wisdom. And to come in and think that just because I'm new or the latest thing and know better than everybody who comes before me would be an act of hubris, inappropriate to the judicial role.
Can you tell me whether Roe was decided correctly?
Senator, again, I would tell you that Roe versus Wade, decided in 1973, is a precedent in the United States Supreme Court. It has been reaffirmed. The reliance interest considerations are important there, and all of the other factors that go into analyzing precedent have to be considered. It is a precedent of the United States Supreme Court. It was reaffirmed in Casey in 1992 and in several other cases. So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other. Basis of precedent, as you point out. If I were to start telling you which are my favorite precedents or which are my least favorite precedents, or if I viewed precedent in that fashion, I would be tipping my hand and suggesting to litigants that I've already made up my mind about their cases. That's not a fair judge. I didn't want that kind of judge when I was a lawyer, and I don't want to be that kind of judge now.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
In numbers, 44.
It has been reaffirmed many times. I can say
Yes.
that, yes.
Yes, dozens.
Yeah.